Hi, I'm attorney John Mangan. I'm a board certified lawyer in the area of wills, trusts, and estates. And in that role, I often get questions from clients about, do I need a revocable or an irrevocable trust when it comes to Florida estate planning? Well, the short answer is it depends. But I'm here today to try to give you a little bit of an overview between each of those types of trusts and just to explain where each of them might be used. So let's start with revocable trusts. As the name connotes, revocable trusts can be revoked at any point in time, meaning they can be terminated if you choose. They can also be amended at any point, as long as the grantor or the owner of the trust is alive and still has capacity. They are very flexible documents since you can make changes at any time. You can also put assets into a revocable trust and take assets out at any point. And there are no complications when it comes to a tax filing perspective. So any income that's owned inside of, or earned, I should say, inside of the revocable trust would just flow over to your individual income tax return, your 1040 that you file every year. You also get some protection on a revocable trust in the event of your disability. And what I mean by that is that in this type of trust, you will name a successor trustee who can take over from you. I'm assuming that you're the initial trustee. That doesn't have to be the case, but it often is. But you're naming someone that can take over in the event of death or disability. It's typically someone you know very well and you have a high level of trust and confidence in. Okay, so you've heard a little bit about what a revocable trust is and how that works. Now let's look at an irrevocable trust. So there are some significant differences here between the two. As you might imagine from the name, irrevocable trusts are very difficult to change. Notice I didn't say impossible. There are a few ways where changes can be made, but just understand it's a lot more difficult. It's a lot more time consuming and typically incurs greater charges to try to make changes to irrevocable trusts. Another aspect about irrevocable trusts is that typically you lose some control. So whereas with a revocable trust, the trust owner, the grantor, might also be the initial trustee of that trust, with an irrevocable trust, especially here in the state of Florida, that grantor generally should not be the trustee of the trust. So again, you're going to name somebody that you trust, you have a high level of confidence in, but you're also giving up control immediately to that person when you put assets into this trust. Also, taking assets out of the trust once they've been in, that's a little more cumbersome. It's not as easy as you just calling up your broker or making a visit down to your bank. Now the trustee is the one who has the authority and decision-making power to remove assets from the trust. So you might be asking, well, it sounds like there are a lot of downsides to an irrevocable trust. I'm giving up flexibility. I'm giving up control. Why would someone want to do these things and have an irrevocable trust? Well, there are three specific circumstances where an irrevocable trust may make a lot of sense for someone. Number one is for asset protection reasons. When assets are transferred into an irrevocable trust, when it's structured for this purpose, significant asset protection can be afforded to the beneficiaries of this trust. Those could be a spouse, they could be descendants, children, grandchildren, etc. But very significant barriers can be put in place to the money that's benefiting these beneficiaries, where if they were ever sued, it's going to be very challenging for that creditor or that claimant to come in and take assets out of the trust. The second reason why someone might want to go with an irrevocable trust has to do with tax benefits. Most commonly, this is in a situation where we're either dealing with already or foreseeing that we might have a situation where estate tax could be owed in the future upon death. Using an irrevocable trust can defray or minimize, reduce the amount of estate taxes that your estate ultimately ends up paying. The third circumstance in which someone might want to use an irrevocable trust has to do with a specific type of beneficiary, a special needs beneficiary, if you will. So if a beneficiary of the trust is someone who has already qualified for a government-funded program, or perhaps intends to apply for one in the future, and if that program, as part of their due diligence, has an asset test and an income test where they're looking to see, does this person truly qualify on a financial basis, Well, an irrevocable trust can be structured in a way where the assets and the income do not count against the beneficiary. Whereas if we just gave those assets to the beneficiary outright, now they would be includable in that qualification process. Now, I've given you a lot of the differences between these two types of trusts. There is one similarity, and that is both of these can be used to avoid probate. Probate really is a topic for another day, but just to briefly define that in case you're not familiar, probate is the formal settlement of an estate after someone passes away. In Florida, it's typically going to take at least 6 to 12 months. It's not inexpensive to go through this process. So to the extent that probate can be avoided or minimized, that's generally a very helpful thing to the beneficiaries of the person who has passed. So you may be wondering, which type of trust makes more sense for you, revocable or irrevocable? Well, the short answer is it depends. But we invite you to reach out to our office, and we can help you to sit down, evaluate your circumstances and your options, and make a prudent decision on which is the better fit for you and for the people that you care about. We look forward to talking with you soon.